Hi everyone, my name is Lean Tran Layton and I'm a managing partner here at JLJ Law Group, and I practice immigration law. I've been doing it for about 10 years now, and I've had the pleasure of working with people from across the country, around the world, advising them on U.S. immigration law. So it's been great to be able to meet so many different people from different walks of life. So in today's video, I'm going to be talking about the new public charge rule that's coming out October 14th of this year. As a disclaimer, all the information that I talk about today is considered general information only. It should not be considered legal advice. Make sure you talk to an experienced immigration attorney if you do have any questions about your case, because every case is so different that I want to make sure that you're getting the right information for your particular case. So, a little bit of background about this public charge rule. So since 1882, the immigration laws have actually laid out that a person has to prove that they are self-sufficient, meaning that they have enough assets or money, or they can rely on family members for basically their living, and they're not going to be a burden on the government and apply for public benefits. So for as long as I've been practicing, and even before that, there's a form I-864, which is the financial affidavit of support. So anybody who's petitioning for a family member to get a green card has to fill out that form. And it's basically a form that says that you make over a certain amount of money and that you have the assets and resources to financially support the intending immigrant, and that the intending immigrant will not become a public charge. So for a long time, and up to October 14th of this year, that form will be enough. Now, if the joint sponsor, or excuse me, not the joint sponsor, if the petitioner doesn't make the required income requirement, then the person can get a joint sponsor. And so again, that alone has been enough to overcome any public charge issues. Now it's changing. So come October 14th, there's actually going to be a new test that immigration officials are going to be using to determine if a person will likely become a public charge or is a public charge. So it's called the totality of the circumstances test. So there's several factors in this test that the immigration officer will look at to determine if they think a person will likely become a public charge. So even if a person hasn't been on any type of public benefits, if the officer believes that they will be, there can be a finding. So this totality of the circumstances test, again, there's several factors. So the factors are age. So they'll look at how old is this intending immigrant? Are they, between the age of 18 and 65 or 67? Are they employable? Obviously, an elderly person who is not employable or maybe just can't work, that can be considered a negative. Now, that doesn't mean that the person will be denied. It's just considered a negative. They'll look at the health. So does the intending immigrant have a medical condition that could require expensive medical treatment or long-term institutionalization? Again, in the government's eyes, that could be very expensive. So again, that could be seen as a negative. What is their family status? So they can look at like how many children a person has, what is the family dynamic like, who works, who doesn't. They'll look at assets, resources, and financial status. So they'll look at, again, does the person work? Does the spouse work? What are the balances in their bank accounts? Do they have a home? Is there any equity in the home? What kind of property does the person own? Can these assets that a person has be sold within a year's time for cash? They'll look at the education and skills. So again, does the intending immigrant have higher education, or do they have a certain skill set where maybe they have like a professional license or something like that? They'll look at that. And another thing that they will look at is English ability. So if a person does not speak English well, that could be considered a negative. Anticipated period of admission. So how long is this intending immigrant going to be here? So clearly, if a person is applying for a green card, they're going to be here long term, and most likely eventually going to apply for citizenship. And then again, they will still look at the affidavit of support. So that form is still relevant and still must be filled out. So right now, the income threshold for the affidavit of support is 125% of the poverty guidelines. So for a household of two, it's $21,137 that the petitioner has to show that he or she makes per year, to show that they have enough money that the intending immigrant will not become a public charge. Now, a heavily weighted positive factor, meaning that a very positive thing that officers will take into account is if the petitioner makes at least 250% of the federal poverty guidelines or above. So again, going back to household of two, that would be $41,150 per year. So if the petitioner can show that he or she makes at least that amount, technically the applicant would be considered in the safe zone, and most likely there's not going to be a lot of questions. Now, I mentioned a joint sponsor earlier. Under this new rule, having a joint sponsor could actually be problematic, because they're going to look at that and say, well, okay, so the petitioner doesn't make enough money. Who is this joint sponsor? They're going to look at what is the relationship between the joint sponsor and the petitioner and intending immigrant. You know, is it a family member, a close family member that lives in the same state, or is it a friend that lives in a totally different state? So again, they will look at that. It's very important. So overall, this rule is very arbitrary, in my opinion. It gives the officers a lot of discretion to make that public charge determination. And what I anticipate also is a lot more requests for evidence letters from immigration, basically asking for more proof that the applicant is self-sufficient and they're not going to be on public benefits. So this new rule will also apply to change of status and extension of status applications as well. There may be a possibility that if the officer in his or her discretion determines that a person can overcome this public charge, they can allow the person to pay a public charge bond, which is $10,000. However, because this is a new rule, there isn't even a procedure in place for this yet. So I don't even know exactly how they're going to allow for people to pay for that bond if this public charge issue comes up. So we'll see. I'm sure that hopefully by the time October 14th comes along, that there will be some sort of procedure. I do know that there have been some lawsuits that have been filed to try to stop this rule from going into effect. So we'll see if that does anything. But I would say just anticipate that October 14th, this new rule will go into effect. So if you're applying for a green card after that date, expect to fill out this new form. So this new self-sufficiency form is 15 pages long, and it's basically what you can view as like a financial vetting. So it's the applicant who fills it out. So the person who's applying for the green card is filling this out to show that they will not become a public charge to the US government. So again, I don't know what this form looks like, but some of the documents that I've heard that may be required to be submitted with this form are 12 months of bank statements, proof of assets, possibly even credit reports, which that's a big change. I mean, I've never had to have applicants submit any type of credit report before when applying for an immigration benefit. So again, we'll see what happens when this new rule goes into effect. So just to briefly touch on what are considered public benefits. So cash assistance like Social Security income, TANF, and general cash assistance. So if a person is primarily relying on that public benefit for income maintenance or for like their main living expenses, that will be seen as a negative and considered a public benefit. Food stamps or SNAP, Section 8 housing and rental assistance, those are considered public benefits. Non-cash public benefits would be considered Medicaid, institutionalization for long-term care, Medicare Part D. So again, those are considered public benefits, but they're non-cash. Now, benefits that are not considered public benefits are Medicaid for emergency services, people who are applying for the Affordable Care Act, CHIP, and WIC. So I know that there's been questions about the Affordable Care Act, and actually, so part of this financial vetting, immigration will want to see that the person has some sort of private health care. So that will definitely be seen as, not private health care, health insurance. So that will, private health insurance. So that will definitely be seen as a positive. So again, I will provide a link to the USCIS press release about this so you can read more about it. But yeah, this is a huge change. I think that officers are going to have to wrap their heads around this when it comes into effect. It's pretty gray, and like I said, it gives officers a lot of discretion to make these findings. So if you have any questions, please give us a call at 801-883-8204, or you can visit our website at jljlawgroup.com. Thanks for joining today, and have a great day.